Hi there, how are you doing? Once again, my name is Mutiaba Conrad, a lawyer by profession and also a private law tutor. So basically today in our class, we're going to be looking at yet another interesting offense of theft. But however, before we start on this offense, I encourage you to like, subscribe and share to my channel and also to turn on the notification. There's just a little red button on the lower right hand corner of your screen. Just tap on it, then you would have really subscribe to my channel. Then also for students that require that private tutoring, that personal mentorship from the experts, please feel free to contact us. Our number is just down in the description box. Contact us and we can always make a private arrangement where we put you on our mentorship program so that we're able to guide you. Grades really matter in law school, and we always encourage you from a tender age to ensure that you strive to having the best grades, and this will really have a very big impact on your legal career. So let's start right away with our offense of theft. And basically in this video we are going to be looking at the definition of theft. We are also going to evaluate a number of laws that provide for this offense, and then we'll also proceed to look at the ingredients, and then we'll also look at a number of other legal principles governing this offense. And then also as a bonus, I'll be discussing for you the various defenses that are really applicable to the offense of theft. And some of these defenses include the defense of claim of right. We'll be looking at it, the defense of compulsion or duress, and then we're also going to be looking at the defense of immunity, the defense of mistake of fact, the defense of immature age, and then also the defense of double jeopardy, and also another seventh defense of lack of jurisdiction, and then finally and lastly the defense of intoxication. So let's start right away with the law that actually provides for the offense of theft. And theft is prohibited or provided for under section 254 of the Penal Code Act. It provides basically for the offense of theft. Then also of interest to you is section 261 of the Penal Code Act, which provides for the punishment as not exceeding 10 years. Okay, so very important to note there. Let's proceed very fast and we look at the definition of theft, which was well laid down in the case of Uganda versus Chirabira, Salongo Abbas, and another. The citation is HCT 00CRCS 0207 of 2010. This is the dishonest and permanent disposition, or rather dispossession of a person of an item that ordinarily doesn't belong to a dispossessor. So basically theft, as you know it, this is where someone goes on to take the property of another, and of which the person taking such property doesn't have ownership to the same. The moment they have ownership, then the same cannot amount to theft. Let's proceed very quickly to look at the ingredients of theft, and these were clearly laid down again in the case of Uganda versus Adiebahika and another. It's a case of HCT. The citation is HCT 04 CRSC 2013 number 272. And basically in that case, the ingredients were as follows. Ingredient number one, that there was property capable of being stolen. So it's really very important for an act to amount to theft. There must have been property capable of being stolen. So the property must have value. The moment the purported property that is the subject of theft does not have value, then it can never amount to theft. Please, for purposes of that ingredient, I encourage you to look at section 253 of the Penal Code Act, which provides for things that are capable of being stolen. You know, there are things that are capable of being stolen. They are listed under section 253 of the Penal Code Act. Please go and look at it in material detail. The second ingredient of this offense is that the property was fraudulently taken away by the culprit. So the aspect of fraud is really very important if prosecution is going to succeed with this offense. Then also number three, the intention must have been to permanently deprive the owner of the use of such property. So the aspect of permanent deprival is really very, very important. And then number four, that the theft was carried out by the accused. So again, we must always, in these criminal offenses, put the accused person on the scene of crime, less of which no conviction will be successful. So let's examine these ingredients a little bit more in detail. So let's start with ingredient number 1. The property is capable of being stolen. Here what we mean, as earlier illustrated, is that it must have value. The property must have value. Okay. Authority, look at section 253 of the Penal Code Act, which provides for things with value. Okay. Things capable of being stolen. Then also of interest is the case of Housley versus Republic. It's a case of 1967 East Africa, page 795, where court held that a person cannot be convicted of taking something which has no value at all. So if someone steals something, the first question we'll always ask is, does it have value? If the answer is no, then there is no theft. If the answer is yes, then we proceed to evaluate and look at the other ingredients. And if all of them are in favor, then the offense of theft is complete. So the second ingredient, which is that the property was fraudulently taken away, is what we are now proceeding to examine. I encourage you to look at the case of Uganda versus Adie Vahika and another. The citation which I already gave you, it's a case of 2013, case number 20722. And in this case, basically, court held that the taking of property belonging to another requires proof of what amounts in law to asportation, or what we also call the carrying away, now, of the property of another without his or her consent. So for the offense again to be complete, there must be asportation. Asportation is a legal term which basically means the taking away of something. So there must have the property must have been taken away. There must be that movement from one place to another. If there is no asportation, then there is no offense of theft. Also of interest on that same ingredient is section 254 subsection 6 of the Penal Code Act, which provides that a thing is not taken unless it's caused to move. So this is what I've been talking about. The aspect of movement is really very important. The moment there is no movement, then there cannot be an offense of theft. Very important to note. Okay, the moment the purported property that was stolen stays in the same place and it's not taken away, then that is not theft. Then lastly, the third ingredient is that the intention was to permanently deprive. So yes, the intention to permanently deprive simply means that the accused person must have intended to sincerely take away your property so that you never have it back. Okay, this is very important. Authority, look at the case of Uganda versus Adie Vahika and another, which I already shared with you. The citation is HCT 04CRSC, a case of 2013, case number 272. And basically here, it was observed by court that it requires proof of unlawful taking without legal justification and with the intention to permanently deprive for someone to be said to have satisfied this third ingredient. Then also of interest to you is the case of Rubenga versus Uganda. It's a case of 1985 HCB, where a court held that a person is not liable for an act exercised with a honest claim of right without an intention to defraud. So the moment someone takes this property but with a claim of right, we'll be looking at the defense of claim of right, but basically claim of right means that a person who is taking that purported property actually has a right to it. Okay, maybe because it belongs to them, okay, they have a right by title, or maybe because they are taking that property because you have their debt, okay. So if they have a claim of right and they do not honestly intend to defraud you, then you cannot succeed to charge such a person for theft. And this is really a common scenario. Someone has you have money that belongs to someone, it's overdue, or you have their debt, then they come and maybe in return they take some of your property, and then you run to police to go and open an offense of theft. You will not succeed because the other party will successfully raise the defense of claim of right, and then your criminal suit would definitely have to collapse in a very miserable way. So let's proceed very fast now to look at the defenses to theft. So when you're charged of the offense of theft, what are some of the defenses that are available to you that you can raise? So we are going to discuss some of these defenses, and some of them can actually even apply for other offenses. So please just buckle up so that we start on the various defenses to theft. So the first defense is what we call claim of right, okay, which I was just shortly trying to explain. And this claim of right as a defense is provided for under Section 7 of the Penal Code Act. And then also of interest to you is the case of Oyat versus Uganda. It's a case of 1957 East Africa, page 827. And in this case, basically, a court held that it was a common practice in Acholi for one to hold or seize cattle that had strayed in another person's garden until they are paid. The accused had a bona fide claim without intention to defraud. He wasn't guilty of theft. Again, this is what I was talking about. So the brief facts of this case are that a cow strayed into another person's garden, destroying their very valuable plantations and crops. So they held onto this cow in demand that they be paid for the damages that were made on the garden. Of course, the other person, the owner of the cow, went to police and opened up an offense of theft. And of course, in court, the accused raised the defense of claim of right, saying that, look, I had a claim of right on this cow because the owner of the cow, actually their cow, had destroyed the crops in my garden. So court allowed, and of course he was acquitted, and he was asked to compensate the person who had actually held onto the cow due to the destruction of the crops in the garden. So also of another interest to you is the case of Francisco Sewava versus Uganda. It's a case of 1966, volume 1, East Africa, page 487. And in this case, it was held that, however unfound a claim of right may be, okay, that however unfound a claim of right may be, the appellant should not have been convicted for stealing doors and roofing materials that he claimed were his. Okay, so here what happened is that the accused went and purportedly stole roofing materials and doors, but according to the accused, for him, he was claiming that these are actually his properties. Okay, and of course he was arrested, charged for theft, and when he reached in court, he raised the defense of claim of right, and then it succeeded, court allowed. Okay, so you realize how just slightly wide the court is willing to stretch the defense of claim of right, and really you should really be very careful so that you ensure that proper offenses are always lodged. And in the future, you're going to be working with the office of the DPP. You should always ensure that you evaluate these files very properly so that you give the best legal advice to the police so that they can open up the proper charges. So let's proceed and we look at the second defense, which is the defense of compulsion, also known as the defense of duress. And this is provided for under Section 14 of the Penal Code Act, which provides for that defense. And basically, by way of definition, this is where an accused was or is forced by someone else to break the law under an immediate threat of serious harm befalling him or her or someone else. So basically with duress, here what happens is that the accused person was put under compulsion. They were forced to do a certain act which was unlawful, and they were actually being threatened that if they don't do it, harm will fall on them or on those people that are very close to them, maybe their father, your mother, your wife, or your child. So they are actually forced to break the law due to compulsion or duress. So if that is the circumstance, then you can actually successfully raise the defense of duress. Let's proceed to look at an interesting case of Attorney General versus Whelan. It's a case of 1934, IR, page 518. I encourage you to go and look at the judgment of Manhagan J, where he stated that threats of immediate death or serious personal violence so great as to overbear the ordinary powers of human resistance are accepted as a justification for criminal acts. So again, the force must be overwhelming that is applied on you or the threats. And if that is the case, justification can be sought under the defense of duress or compulsion. Let's now proceed to look a little bit more at the aspect of threats, okay? Because remember, we said that this defense applies where there are threats. So let's evaluate these threats and we see what has court really stated. Okay, what is the position of the law as pertains the aspect of threats? I encourage you to look at the case of Ira versus Singh. It's a case of 1973, volume 1, East Africa, page 122. And in this case, basically, the Court of Appeal held that a threat to expose the accused's adultery would not be sufficient grounds to plead duress. So again, you're seeing that there are certain threats that the court will not allow. You know, if you're held and then, you know, the duress is on threats that, you know, your adulterous nature will be exposed, then that is not sufficient enough and you'll not qualify under the defense of duress or compulsion. Also, let's proceed to look at another case of DPP for North Ireland versus Lynch. It's a case of 1975, East Africa, page 653. And here, basically, Lord Simon stated obiter that the law would not regard threats for a person's property as a sufficient basis for the defense. You know, this is what the judge really held. That is Lord Simon, although it's a little bit debatable, but really this is the position of the law. Also of interest is the case of Ira versus Halley. It's a case of 1967, VR, page 526. Here, the Supreme Court allowed the defense when the threats had been made towards the accused's girlfriend with whom he was living at the time. So you're seeing that you can also rely on this defense if threats are directed towards your girlfriend, but not actually to property, as was held in DPP of North Ireland versus Lynch. Let's proceed also to look at the principle governing this defense and specifically governing threats. The principle here, and please note, principles are very important even when you're doing your exams. Always state out very clearly what the principle governing what you're talking about is. And here the principle is that the threats must be directed at the commission of a particular offense. Here what we mean is that those threats for which you want court to allow your defense of duress or compulsion, those purported threats must be directed to the commission of a particular offense. That someone threatened you, and because they threatened you, they directed you to go and specifically do a certain offense so that the threats are not put into action. Another interesting case is the case of R versus Coles. It's a case of 1994, criminal LR, page 582. And basically in this case, it was held that the defense of duress by threats was only made out where the threatener nominated the crime to be committed by the accused. So the threatener must have not nominated the crime. You know, if it is you choosing the crime for yourself, then believe me, you may find it extremely hard for you to convince court so that the defense of duress is availed to you. So let's proceed, ladies and gentlemen, to look at the test for duress. What is the test? Okay, for the victim to rely on this duress, what is the test that court will always apply for you to qualify under this defense? That's what we are going to look at. And I invite you to look at the case of R versus Howe. It's a case of 1987 SC, page 417. And basically in this case, the House of Lords held that the court should consider, one, whether or not the accused was compelled to act as he did, because on the basis of the circumstances, as he honestly believed them to be, he thought his life was in immediate danger. That is the subjective test. So the first test that court will apply is a subjective test, that in the position of the accused person, can we say that his life was in immediate danger as themselves viewed it? Did they view their life to be in immediate danger? If the answer is yes, then the first test would be satisfied. If the answer is no, then of course the first limb of the test would have failed. Then also secondly, the other second limb of the test is, would a sober person of reasonable fairness, sharing the accused's characteristics, have responded in the same way to the threats? That is the objective test. We'll again ask that if it was another person in your situation at that material time as you were, would they really have also acted as you? If the answer is yes, then you would have successfully passed the test to qualify to rely on the defense of duress. If the answer is no, then you will not be successful to rely on the defense of duress. Let's now proceed to look at another element of this defense, which is immediacy. Okay, immediacy, from the word immediate. And please note, when you're discussing this defense, you must lay down all these aspects that I'm laboring to discuss for you. The aspect of immediacy, the aspect of the test. You should also go on to analyze and evaluate what actually amounts to a threat. Of course, you should do this when in an exam. Do it in a summary manner. Do not be wordy, as this will really cost you your having good grades. So let's proceed now to look at the aspect of immediacy under the defense of duress. So the principle basically governing the aspect of immediacy is that the threat must be immediate or imminent. This is really very important. The threat must be immediate or eminent in the sense that it is operating upon the accused at the time that the crime was actually committed. Immediacy is very, very important. The moment it is not immediate, then you will not succeed to rely on this defense. Authority for that position, I encourage you to look at the case of DPP for North Ireland versus Lynch, a case which I already shared. Citation is 1975, SC page 653. Look at the judgment of Lord Moms, where he held that the question is whether a person, the subject of duress, could reasonably have extricated himself or herself, could have sought protection or had what has been called safe avenue of escape. So court will always evaluate and see, okay, that at that material time when you are under duress, did you have any room to escape? Okay, you may have had room to escape. If the answer is yes, then you will not succeed. That means that there is no aspect of immediacy, okay? But if you had no room to escape or to go out of it, then the aspect of immediacy would have been attained. Then lastly, second to last on this defense, let's proceed to look at the aspect of the burden of proof. Who has the burden of proof on this defense? The accused bears the burden of introducing evidence of duress, and it is up to prosecution to prove beyond reasonable doubt that the accused was not acting under duress. If the defense is established, it will result into an acquittal. So, of course, the burden of proof is on the person who intends to rely on the defense of duress to bring evidence to show that actually they were under duress. And when they bring that evidence, then it is up to prosecution or up to the DPP then to disqualify, okay, or to dismantle that evidence to show that actually the accused person was surely not operating under duress. Final on this defense, let's proceed to look at the limitations of this defense. So the defense does not apply to the following. One, murder. Very important. This defense, ladies and gentlemen, I emphasize, we don't want to see you in your exam writing for us answers and giving us the defense of duress or compulsion applying to the offense of murder. Murder, it doesn't apply. Very important. And this was clearly laid out in the case of Ira versus Home and others, a case of 1987, SC page 417, whether as a principal or as an accomplice, it doesn't really matter. So the other offense where this defense does not apply is the offense of attempted murder. And again, this was emphasized by court in the case of Ira versus Gotts, a case of 1992, volume 2, SC page 412, and here Lord Johnsey held that the defense doesn't apply to attempted murder. Very, very important to note as a student. Let's now proceed to look at our third defense, which is the defense of immunity. The defense of immunity. Now, it's important to note from the onset that this defense of immunity is mainly divided in about three. It's divided in what we call presidential immunity, and then it's also divided into diplomatic immunity, and also finally what we call judicial immunity. We are going to be bisecting and unpacking each of these three limbs of the defense in material detail. And let's start with the presidential immunity. The law governing presidential immunity is under Article 98, Clause 4 of the Constitution of Uganda, which of course exempts the president from proceedings in any court while holding office, although proceedings can be instituted when he is out of office. You look at Article 98, Clause 5 of the Constitution. And the limitation doesn't apply for the period a person is a president, according to Article 98, Clause 5. So here what we are saying is that the president has immunity. Okay, you cannot subject them to criminal proceedings. But that is when they are still in office. The moment they get out of office, then such a cause of action or such a suit can always be instituted against the president. But it's also important to note that for that time when the president is in office, the limitation time does not run. Okay, so the limitation time does not run. Here what we mean is that if the president has been in office for 40 years, after the 40 years, the president cannot really raise the defense of limitation to say that, look, according to the Limitation Act, the contract was signed 30 years ago, and the Limitation Act states that after 3 years, you cannot bring, for example, a cause of action. So meaning that causes of action against the president are not limited when they are in office. The limitation period only starts to run when they actually get out of office. I encourage you to look at a very interesting case of Professor Gilbert Baliba Sekabukenya, who is the former Vice President of Uganda, versus the Attorney General. It's constitutional petition number 30 of 2011. It's an unreported case, but here basically the court held that presidential immunity is only a presidential protection which eliminates or postpones the accuser's ability to slap a claim on the president. Very, very interesting decision of court. Let's now proceed to look at diplomatic immunity. Now, basically, diplomatic immunity is the general exemption of diplomatic ministers from the operation of local law. Okay, that definition was clearly laid down, or you can find it in the Black Laws Dictionary, 9th edition by Brian A. Garner at page 819. Let's now proceed to look at Article 31, Clause 1 of Article 31, subsection 1 of the Diplomatic Privileges Act. It provides for diplomatic agents immunity from criminal jurisdiction. So these agents are also provided for from criminal jurisdiction. Also of interest is Article 1E of the Diplomatic Privileges Act, which basically defines a diplomatic agent as a head of the mission or a member of the diplomatic staff of the mission. Very, very important for you to note there. The burden, let's proceed to look at the burden, and basically the burden pertaining to diplomatic immunity is on the accused, okay, who pleads the defense, to prove that he or she is a diplomat and that the nature of the offense entitles him or her to diplomatic immunity. Please look, authority for that position can be found in the Uganda Criminal Justice Bench Book, first edition 2017, published by LDC. You'll find the proposition on the aspect of the burden being on the diplomat who intends to rely on the defense of diplomatic immunity. Also of interest to you is Article 31, Clause 4 of the Diplomatic Privileges Act. You'll be interested to know why actually these are known as articles, yet they are under the Diplomatic Privileges Act. That one is your duty to go and investigate. Please go and investigate and let me know down when you're making comments. Why is it that these are referred to as articles, yet they are actually under the Diplomatic Privileges Act? So Article 31, Clause 4 of the Diplomatic Privileges Act provides that the diplomat is not exempted from the jurisdiction of the sending state. So these diplomats, even when they qualify for diplomatic immunity, but however, they are not exempted from jurisdiction, okay, of the sending state, meaning that the state that sends this diplomat can actually still charge him, okay? Although in the country where the diplomat is sent, he can always claim this defense. Also of interest to you is Article 32, Clause 1 of the Diplomatic Privileges Act, which provides that the immunity of these diplomats may be actually waived by the sending state, although the waiver must be express, okay? Look at Article 32, Clause 2, again, of the Diplomatic Privileges Act. So basically, that's it on diplomatic immunity. Let's now proceed to look at judicial immunity. Judicial immunity is provided for under the Penal Code Act, specifically Section 13, which exempts judicial officers from criminal liability for acts in exercise of their judicial functions. So ladies and gentlemen, judicial officers are immune whenever they are doing their work in court. Also of interest to you is Article 128, Clause 4 of the 1995 Constitution of Uganda, which basically gives judicial officers immunity in exercise of their functions. A very interesting case that you must all go and read. Very interesting, again, judgment of my best judge, who is Justice Stephen Mubiru. That is the case of Opio Joseph Otiti versus MS Oyet and Company Advocates and 4 others. This is civil suit number 0019 of 2016. Very interesting judgment, but I'll just give you just the holdings of Justice Stephen Mubiru. He makes a very interesting discussion really on judicial immunity, and he held as follows: that the doctrine of absolute judicial immunity will therefore protect a judge against liability for a given act if 2 conditions are satisfied. You know, so for a judge to actually rely on judicial immunity, there are around 2 conditions that must always be satisfied. And the first one is that the act must not have been taken in the clear absence of all jurisdiction. So there must have been jurisdiction for the judge to actually rely on judicial immunity. And then secondly, the act must be a judicial act. Very interesting. Actions in excess of but not in a clear absence of jurisdiction too, are covered by that immunity. And then secondly, Justice Stephen Mubiru also held that a judge's immunity extends to grave procedural errors, malice and corruption, collusion and unprofessional acts. Very, very interesting. What the judge was trying to say, that the scope of judicial immunity is very wide, to the extent that even if the judge actually acts corruptly, or even if actually the judge acts with grave procedural errors in the way they are actually administering the case or the due process, or even if actually the judge acts in collusion, and even if the judge acts unprofessionally, the judge is still protected by the doctrine of judicial immunity. Very interesting judgment. Ensure that you go and read it before close of today. And then also number 3, Justice Stephen Mubiru held that the factors determining whether an act by a judge is judicial, one is a judicial one, relate to the nature of the act itself, i.e. that whether it is a function normally provided by a judge, and to the expectations of the parties, i.e. whether they dealt with the judge in his or her judicial capacity. That will always be interrogated. And then lastly, such complaints against a judge can only be dealt with by the Judicial Service Commission. So Justice Stephen Mubiru was saying, and indeed this is the position of the law, that even if it doesn't matter how the judge acts, okay, corruptly acts with errors, it doesn't matter, they are still protected by judicial immunity. But he wasn't saying that they actually cannot be brought to book. No, the judges can actually be brought to book, but your remedy actually lies with the Judicial Service Commission. That's where you can lodge your complaint against such a judge. And we have seen a number of cases where the Judicial Service Commission, even recently, it makes many decisions always to dismiss judges and magistrates who act unprofessionally. But however, your remedy lies with the Judicial Commission, but it doesn't lie in a suit. So you cannot bring a suit against such a judge, otherwise they will plead judicial immunity and your case would collapse. Let's now proceed to look at another defense, which is the defense of mistake of fact. This is provided for under Section 9 of the Penal Code Act. And basically the principle governing the defense of mistake of fact is that an accused person who commits an unlawful act but mistaken as to certain material facts, these negative mens rea. It must, however, not be a mistake of law or the consequences of the act. That is the principle governing mistake of fact, and it was laid down in the case of Liosoni alias son of Matteo versus R, a case of 1961, East Africa, page 364. Very, very interesting principle there to note. Also of interest to you is the case of Ira versus Sultan Majinga, a case of 1967, High Court Bullet, page 33. And basically this case is really interesting. Please go and look for it and read it in detail. But basically here, court held that a person is not liable for acting honestly and reasonably, but mistakenly as to the existence of things. And also lastly, in the case of R versus Prince, a case of 1875, LR2 CCR, page 154, here court held that if no mens rea is required with regard to one element of the actus reus, then even an honest and reasonable mistake with regard to that element will not negative liability. So basically, when we are talking about the defense of mistake of fact, here what we are meaning is that the person who has been charged for a criminal offense is basically trying to say that, look, I was mistaken as to the nature of the facts, and I was not mistaken as to the law, but rather to the facts. Okay, very, very important. Go and read the case of Sultan Majinga. Very interesting case. It puts up very good, interesting facts on this defense. So mistake of fact, really, this is a defense that applies where you were mistaken, okay, as to the facts or as to something which made you to act in a certain way unknown to you. Okay, you'll go and read that case of Sultan Majinga. It's very interesting. But just briefly to trigger up your mind, there was a lady and a man who were having sexual intercourse in a bush. So this guy really comes, and there was a lot of grass, Unknown to him, he saw the grass shaking, and then he actually thought that it was a wild animal in the bush that was going to attack him, So because he was not seeing, but he was seeing the grass, he was not seeing the wild animal, but he was seeing the grass shaking, and it was really deep down in the forest. So he thought it was a wild animal, and what he did, I think he first called out a number of times and there was no reply. So he threw a spear, and which of course ended up damaging, and hitting both the lady and the man that were having sexual intercourse in the forest. And of course, an offense was opened up on him, I think, of murder. And while in court, he raised the defense of mistake of fact, and court allowed that actually he was mistaken as to the facts, thinking that it was a wild animal in the bush, whereas actually these were two human beings that were going on with their business. So that's how basically the defense of mistake of fact applies. Let's now proceed to look at another defense, which is immature age as a defense, or also known as the defense of infancy. Authority, where can that defense be found? Look at section 88 of the Children's Act, which provides for the age of criminal liability as 12. So meaning that a person who is below 12 years cannot be held criminal liable for an offense that they have committed. On top of that, another interesting authority is the case of Walters versus Lant. It's a case of 50, the citation is 53, Criminal Appeal R, page 94. And basically in this case, court held that a father cannot be held guilty of receiving stolen property from his son aged 12 years because the property was not stolen in law. So basically what happened here, a child went and stole property, and the child was below 12 years. He came and handed it over to the father, and police tried to bring up the offense of receiving stolen property against the father who had actually received the property from the child. So court held that actually no, the child cannot be held, the father could not be held liable for the offense of receiving stolen property, because from the very beginning, the child who is 12 years who had actually stolen the property could not have stolen it. Why? Because the child was below 12 years and therefore he could not be held criminally liable. Let's now proceed to another defense of double jeopardy. So basically the defense of double jeopardy, this is provided for under the law. I encourage you to look at Article 28, Clause 9 of the Constitution, which provides that a person tried by court or convicted or acquitted shall not again be tried for the same offense. So basically the defense of double jeopardy here, we are looking at a scenario where a person has been charged and the sentence passed, but then the same person, criminal proceedings have been brought up on him, for the second time, on the same facts, same everything, so such a person would raise the defense of double jeopardy. A person is not allowed to be punished twice for the same offense. Let's now proceed to look at our second last defense, which is the defense of lack of jurisdiction. Basically, this is provided for under law. I encourage you to look at Section 4 of the Penal Code Act, which provides for the defense by limiting court's jurisdiction within Uganda's boundaries. So the lack of jurisdiction, basically, this defense applies to say that, look, these courts that are trying me do not have jurisdiction over me. The authority for that position, another interesting authority, is the case of Uganda versus Alena Mustafa. It's a locus classicus on lack of jurisdiction. It's a case of 1975, High Court Bullet, page 253. Go and look at it, but just in summary, court held that court did not have jurisdiction to offenses committed out of Uganda unless a specific act authorizing the same was passed. Now, interesting to note that this case was of 1975. It lays down the principle for purposes of your understanding, but it's important to note that because of this case, actually an amendment was done later on in the Penal Code Act and in various other Ugandan statutes. But for purposes of appreciating the principle, please take home that case in that context and go and read the case in material detail. Then lastly, the defense we're going to be looking at is the defense of intoxication. Intoxication. Authority that provides for this defense, look at Section 12, subsection 2 of the Penal Code Act. It provides for that defense. And basically the principle governing intoxication is that the intoxication must or was caused without one's consent by the malicious acts of another party. So acts of self-intoxication, if you go on to take your beer or your whiskey, and then you go on to commit an offense, believe me, we shall arrest you and we shall hold you criminally liable. But here you can only rely on the defense of intoxication if actually at the time of committing such an offense you are intoxicated, that you did not understand what you were actually doing, or if you did, then you did not understand that it was actually unlawful. The test that is important for you to note for an accused person to be able to sustain and be successful under this defense is that the intoxication must have been administered by another party without your knowledge. Okay, very, very, very important. If you can show that, then court will avail you and allow you to proceed and rely on the defense of intoxication. So ladies and gentlemen, that is really all for today. Thank you very much for hanging on until the end of this class. Again, I encourage you to subscribe, like and share my channel. Also turn on the notification, and also students interested in this personal mentorship and also personal tutoring, we can always put you on our expert program and we'll get you professionals to help guide you, teach you so many other things. And please students, these classes are really summarized classes, although we do every single attempt to ensure that we take you through the law in detail, but however this can only be a very small piece of what actually the law is about. So ensure that you get yourself onto a package, let our experts mentor you, let our experts train you in your holidays while at school. You can always make those private arrangements. Thank you very much. Our contact is down in the description box. You can always call us directly for your for that extra polish and touch. Thank you very much. We meet again in another class. See you. Bye-bye.